Well, it's the political season, and we're talking about politics this morning, but this is the one that has to do with the local levels in a particular state. Ebonyi State is our focus this morning, and there's some controversy brewing as a federal high court in Abakaliki has nullified local government and councillorship elections which were conducted in the state on the 30th of July this year for non-compliance with the Electoral Act 2022. We have two gentlemen to discuss the judgment of that court. Mr. Mujaga Erenede, who is a legal practitioner, joins us here in our Abuja studios. Good morning, and you're welcome.
Thank you very much. And
we also have with us, joining us via Zoom, Mr. Uchenna Orji, who is the Commissioner for Information in Ebonyi State. Commissioner Orji, good morning, and it's good to see you.
Good morning. My pleasure always.
Let me start. Thank you so much. Well, let me start with you, Mr. Erenede. This is the ruling of the Federal High Court, and it would seem that, you know, there are questions. We understand that those who contested in the elections were a little confused as to which particular set of laws were going to be used. Let me quickly see if I can find some words which were used in the judgment. They said Justice Fatun Rima ruled that the Ebonyi local council elections that are held in the 13 local councils in the state on the 30th of July was undemocratic, unlawful, and therefore null and void.
Yes.
Undemocratic and unlawful for elections that were conducted in a democracy. Pretty strong words from a court. So what precisely made the court reach this decision?
Yes, quick one. Thank you. Long before the elections took place, the purported elections took place, we wrote to the Ebonyi State Independent Electoral Commission on behalf of our clients, demanding to be availed of that law that they intended to use in the conduct of the elections. Strangely enough, EBSEC, that's the acronym for the Ebonyi State Independent Electoral Commission, responded in writing to us, telling us that they are not lawmakers and that we should write to the House of Assembly. That's strange.
They wrote it, they put it in writing?
They put it in writing. We have it. It's part of the documents we presented to the court.
That they are not lawmakers?
That they are not lawmakers and that we should write to the Ebonyi State House of Assembly. However, because we wanted to cover the grounds, we also did a letter to the Ebonyi State House of Assembly. And because there is no proper, in fact, in law, there is no House of Assembly in Ebonyi State right now. We sent that mail by DHL. Of course, that mail was never returned to us, so we assume, and rightly so, that that mail was delivered. No response from the House of Assembly. We also wrote to INEC, which is the body that has custody of the register, the voters' register, with which EBSEC was to conduct that election. INEC did not do anything. And we took it a notch higher by filing an action.
What did you want INEC to do? I mean,
not to release, to give us the law, because INEC is not a rubber stamp agency. If tomato sellers want to conduct elections, they cannot go to INEC and say, give us voters' register. So it presupposes that INEC should have a basis, a legal basis for releasing the voters' register to anybody that wants to make use of it.
But isn't that taken for granted? I mean, some people will just say you were stretching this by writing to INEC.
Yes, we needed to do that because now that they did not comply, INEC is a party to that suit. We needed to create a basis for making INEC a party. INEC did not respond because we took it that INEC must have been furnished with the extant law that EBSEC intended to use for the conduct of that election before releasing the voters' register to them.
Are you questioning the basis of EBSEC's existence?
We are not questioning the basis of EBSEC's existence. We are rather questioning the modus, the way EBSEC does its job.
I understand. I mean, what I'm saying is when you write to INEC, because INEC is the Independent National Electoral Commission, empowered by law to conduct specific kinds of elections. EBSEC, by its own constitution, would also be, empowered to conduct specific, kinds of elections. One does not have regulatory oversight over the other.
Yes.
They are independent bodies, but they cooperate, based on what their jobs are. So when you say you write to INEC, there'll be questions as to whether you're not just trying to involve INEC as a meddlesome interloper in this instance.
That's why I gave the instance of tomato sellers. I'm just trying to take it to the basest level.
Yeah, but EBSEC is not tomato sellers.
That's what we are saying, because it's a lawful body.
Indeed.
That must operate within the ambits of the law. Section 150 of the Electoral Act has said everything the state commissions do must be the same. The procedure for the conduct of elections by state commissions must comply with that of area councils in the Federal Capital Territory. And this has constitutional backing. Therefore, INEC cannot keep a blind eye on the procedure of the state commission, in this case EBSEC, if they really wanted to do a proper election.
Okay, so for you, why was the law that EBSEC was going to use, why was it important to you?
It's important, very important, because one, the rumor was all over the place that a law had been made. A law had been made by the government of Ebonyi State.
Not by the State House of Assembly?
There is no House of Assembly in Ebonyi State.
So when you say government...
Following the judgment, there is no... I'll come to it if we have the time.
Was the law going to come from the executive arm of government? Or
all kinds of things are happening in that state. If we have the time, we'll discuss it. Now, you say you have a law. What is difficult in making that law available to members of other political parties who intend to take part in the elections? If we don't have the Electoral Act in circulation, if Nigerians don't have access to the Electoral Act 2022, you can be rest assured that many of these people who are candidates today would have run foul of the provisions of that Electoral Act. And all we wanted, very simple, elementary demands: make that law available to my clients. We also, in that letter, gave an undertaking to pay whatever the cost of production could be. Certified true copies, whatever version of it, official gazettes. Of course, there are no gazettes in Ebonyi State. There's nothing like official gazettes. Everybody, this is common knowledge. So we wrote, and the question, one of the questions the court answered in that judgment: what is difficult in releasing that law to the plaintiffs? What is the secrecy about? Section 167D of the Evidence Act 2011 says, let me paraphrase, I don't want to quote. Anybody who withholds evidence or documents that the other side has demanded for is presumed that the contents of that document will be unfavorable to him, and that is why he is keeping it. Give us the law so that we can advise our clients on the do's and the don'ts.
Okay, so the law weren't given to you.
It wasn't given to us.
Did you eventually did your clients end up participating in the polls?
How could we participate in an election we don't know the rules? That's like walking into a trap. Now, there's an aspect Nigerians would need to know. Prior to that election, we brought an interlocutory application for injunction to stop EBSEC from going ahead with that exercise until the action we filed for freedom of... We brought an action under the Freedom of Information Act for the court to mandate these bodies, Ebonyi State Government, EBSEC, and INEC, to release this document to us. While that suit is still pending, in their usual way of disregarding the law and decisions of courts, they published a notice that they were going on with the elections. That was what gave rise to this suit that brought this judgment. Now, we filed an interlocutory application for injunction when we saw they were prepared to go on. The judge, in his wisdom and discretion, said by the provisions of Section 84, sub 15 of the Electoral Act 2022, the courts have been divested of powers to use injunction to either stop elections or party primaries. But refused now to grant this injunction and warned. The chairman of EPSEC was in court on that day. The court said the principle of lease pendants, when a suit is pending, no party is expected to take steps that will render the outcome of that suit academic, and said, much as an injunction has not been formally granted, parties should maintain the status quo. It would not cost EPSEC anything if they just await the outcome of that suit. But EPSEC, the very next day, went and conducted these elections.
Okay. Well, let us find out from Mr. Ojena Oji why that was the case. I do not know just how much the government is aware of the happenings in EPSEC, because I want to imagine that it's supposed to be an independent body, but maybe, following the events that have now happened in your state, and I'm sure that the government will be aware of this. Just wondering, how much can you tell us of what you know in terms of the application they made to EPSEC and what has now finally culminated in the judgment which has been delivered by the Federal High Court in Abakaliki?
Yeah, thank you, Mope. Thank you also, Barrister Erenide. Let me say that Ebonyi State Independent Electoral Commission is an independent commission mandated by the law of Ebonyi State to conduct election. And by the effect of Section 7 of the Constitution, 1999 as amended, so 4 and 5, the independent commission of every state has the exclusive powers under the law creating it to conduct election. Under that very section, the role of INEC is only to avail the voters register, nothing more, nothing less, and no much ado about that. Having said that, the position of Barrister Moody calls to mind the principle of ignorance of the law. That is no excuse. Of course, ignorance of the facts, the implication. Now, let me mention that the litigants that went to court on the 27th day of July 2022. And that was 2 days after the Federal High Courts went on vacation, including the Federal High Court sitting in Abakaliki. And the implication is that that Federal High Court couldn't have entertained in the first place the suit. And unfortunately, again to them, the sitting or presiding judge of the Federal High Court in Abakaliki was not part of those listed in the circulars of Federal High Court of 25th day of July 2022 to preside over matters. Assuming without considering that that court was meant or slated to preside over matters, the matter presided upon by that court was not contemplated. The court says only specially or urgent, extremely urgent matters. And the Federal High Court circular went ahead to mention the categories of matters that should be entertained. For us, it's just a matter that died a stillbirth. Having said that, let me mention that the litigants, through the lawyer that is before us here, cited Section 150 and Section 103 of the Electoral Act. And I make both to say that independent commission, Electoral Commission of Ebonyi State, never did offend an iota of any of the provision of those sections of the Electoral Act. In terms of holding election, that should not be earlier than 150 days. In terms of holding election, that should not be later than 30 days. In this instant case, Independent Electoral Commission of Ebonyi State did hold election not later than 30 days. That is to say that they held election on the 30th.
Mr. Oji, before you move on to the next other points that you want to make, now, in the initial point that you highlighted, where you say you question the judgment in the first place, the Constitution, those who presided over it, those who were listed and who were not, is your position such that the judgment, as far as the state or as far as you are concerned, doesn't hold or doesn't hold water, doesn't stand? Or what exactly?
Yeah, the council there in studio has mentioned it. My mind as a lawyer is a mere academic exercise. Let me make the points clear. What are those reliefs sought? There were declarative reliefs. There were injunctive reliefs sought. The crux of the matter is that they were saying or seeking for court to direct that elections should not hold, to direct that INEC should not avail the voters register.
No, now you're moving to other points. So I'm asking, now that you're questioning those who were listed, those who were not, suggesting the judgment doesn't stand, so as a lawyer, what is the usual procedure if that were the position that you hold?
I am going to come to that.
Well, you have to come to it now because of time.
Yeah, we have a lot of opportunities of appeal, opportunities of setting aside, opportunities of taking other legal steps under the Constitution, under also the extant laws. But I'm not going to discuss that.
Okay, so
I'm sure actions have been taken.
All right,
Some
so what that
already in process.
So what that means is that whether or not you agree or disagree with the judgments, the procedure is you have to go to court and vacate it before you can do anything further. Is that right?
I have mentioned that we have all the options under the law. I'm not going to avail it because
I'm not asking the options you have. I'm only asking what is the standard practice? If one party or if a certain party doesn't agree or agrees with the law, what is the usual practice? Isn't it to go to court and vacate it before you proceed further?
You can challenge it on appeal, and if it's an extremely bad case like this, you can direct or you can go to court, the same court, to set it aside.
So to that extent,
also other applications, including applications of motion and expert applications that can also avail you certain reliefs.
Right.
I'm not going to mention it here.
Okay,
but
so
it's good to make the point.
No, just a minute.
To understand.
Don't worry, we'll take it point by point as much as we can. So to that extent, the judgment stands, it holds. So you have to go ahead, vacate it before you move on. Now, having said that and established it as you also have said, some of the issues raised there in the judgment is that, as you also heard the lawyer say, is that they wrote to the State Independent Electoral Commission to avail them of the laws. They did not oblige them. They wrote telling them, go meet the lawmakers. We're not lawmakers, from what his account is. And that's a part of the basis upon which the elections were nullified. So are you aware, do you have any contrary information that parties in the state were availed the laws with which the elections were conducted?
Let me tell you that about the practice and procedure under the law.
I'm not asking about the procedure. I mean, do you have information if they have the laws? Were they given the laws upon which elections were conducted?
Yeah, I'm coming to that. I said there are two documents that EBSEC works with. Two working documents. One is the law establishing it. That is the law that has to do with the conduct of the election. And two is the guide and the electoral guidelines. I'm aware that under the law, that there are procedures, including calling of stakeholders, that EBSEC did fulfill all those procedures. Calling of stakeholders to talk to them about what the law says, the guidelines. An election was conducted with a guideline. And let me tell you, for goodness sake, EBSEC is not the maker of the law. Or even under the Freedom of Information Act, EBSEC is not even the proper authority to issue you a certified true copy. Let me tell you, in lawmaking processes, we have first hearing, or first reading, second reading, third reading. Even within the period and procedure, you have what is called a public hearing. The House of Assembly duly constituted and being presided over by the most peaceful speaker, have to undergo through the processes. But
okay.
Beyond this, do you know what happened?
Ms. Oji,
This law was gazetted.
Yeah. Do you have
Gazetted as an official.
Do you have any documented evidence that FCA did avail them of the laws that they requested?
You need to get
Any
my point
correspondence
clear.
whatsoever? It's a straightforward perspective.
FSEC had to issue notice of meeting to stakeholders, including political parties. But let me mention, this barrister is a member of PDP. In my local government, for instance,
Mr. Oji, what has that got to do with whether or not FCA gave them the laws for which the elections were conducted?
I am coming to that. I say that they held meetings with stakeholders. And part of the reasoning for the meeting is to avail them of the law, the guideline. It is an extant procedure that cannot be violated. And again, these people that went to court there, we are neither candidates nor aspirants in any political party.
Mr. Oji, just one question, very quick one, so that, I mean, this can be a little simplified. Now, any Nigerian goes to the website of the Independent National Electoral Commission now, even within minutes after the president signed that law, you will find it on the website of INEC and easily download it. You can download 10 copies if you like. Is there a website where this law that you're talking about can be downloaded as we speak?
Yeah, in FSEC, I'm not a staff. But can I tell you as Commissioner for Information?
I'm just asking a simple question.
Okay.
Now, I'm assuming by that you are saying you don't know whether or not INEC has that. I mean, in the FSEC has that on its website. So now you are speaking, you know, about a law that was made by the House of Assembly, and that is supposed to be actioned by FSEC. The question that naturally comes to my mind is FSEC independent of Ebonyi State government?
FSEC is under the law independent.
Okay. So if FSEC is independent, which organ of government is supposed to organize this election?
Is Ebonyi State independent?
Good.
Electoral Commission.
If Ebonyi State Independent Electoral Commission is the one that is supposed to organize this election, what then is the involvement of the state government?
Of course, as provided by the law, funding is part of the duties of the state government.
Okay.
And no more, no less.
Okay.
The law provides for all the procedures, and they have followed the procedures, including availing the laws to the stakeholders.
Now, if the business of government, just a second, if the business of government is just to fund and not be part of the organizing process, how come the Ebonyi State government is the one answering these questions and not FSEC?
Yeah, because Ebonyi State government is a government under the ruling APC, and we fielded the candidates in councillorship and chairmanship in the 13 local government areas. And our candidates won in all the wards, the 171 wards of the state, and 13 local government areas. And so our party, that is the party of the ruling government, won. So we must take every step to ensure that that victory is protected. So that's our duty. This
issue that judgment raised, Honorable Commissioner, is in the timeliness of it. That judgment also says that the tenure of the local government chairmen and councillors isn't expired until this month next year. How come we're organizing the elections now?
Thank you very much. That is part of the ignorance of the law that is no excuse. This is law number 001, Ebonyi State Electoral and Related Matters Amendment Law 2020. Under Section 18, it provides that the tenure of the local government shall be 2 years. And this law was made in January 2020, and the previous local government council, expired on this 1st of September 2020. And so this law has a binding effect, and the council chairmen all know it. They all know it. And I was thinking that it would have been the chairman that would have gone to determine whether their tenure was 3 years or 2 years. But in this circumstance, they are not complaining. They are part and parcel of this process to ensure that democracy thrives in Ebonyi State. And so there is no problem about tenure at all. It's just ignorance of the law. There is no excuse.
So, Commissioner Orji, so if the EPSEC is independent, why then is the State Independent Electoral Commissioner, why did it refer the client seeking information about the law, why did it refer it to Ebonyi State Assembly?
Yeah, if you are seeking information in terms of looking for a certified true copy, and you want it officially, you go to the right authority. I have an authority on that. I'm a lawyer. EPSEC is not the right authority to issue you with certified true copy. And so you need to go to the right place. Otherwise, it will be doing the wrong thing. And it's not part of its duties and powers under the law establishing it, that it must have value. And assuming without conceding that they came to be availed with this law and they were not, with the proper application, will it be to nullify the election? By the way, they didn't. The law, the court did not say that election as has been held should stand nullified. That's not what the law, the court said. They said they have granted the order asking court to stop the holding of election. At that time, election had been held. So it was just an academic exercise. But they didn't do their work very well.
According to the client of the PDP, there was a pending suit that the state government ought to have waited for, or EPSEC ought to have waited for before it carried out the election, ought to have waited for it to be determined before it carried out the election.
I am not aware of that, but that's not the working of institutions. Except that it's a lawful order of court that says, do not hold election, because we are law-abiding state with all the institutions therein. If the court has not said, don't hold election, why will you just go to stop holding election? More so when we are operating within the confines of the law.
One more question, Commissioner Orji. The general tenure for local government elections is supposed to be 3 years. How come this document is saying that the tenure for the local government chairman in Ebonyi State is 2 years?
Yeah, let me tell you that the House of Assembly of every state has the powers to make man woman. And so it has the powers to even tinker with the tenure of the local government, even to the most minimum level. And let me mention that under Section 7 and even the combined effect of Section 8 of the Constitution empowers the state to legislate for the sustenance, for the funding, for the even tenure of local government. And it has the exclusive powers in this regard.
Why then was this document shrouded in secrecy? Why was it not made available when the clients requested it?
I am saying that this law was part of the documents used by EPSEC, including the guideline, to lecture the stakeholders on the holding of the election. I happen to even be one of the people that came to witness that very meeting. And so for you to ask EPSEC to avail of the CTC of this law, it's not their duty, for goodness sake.
How widely publicized was this stakeholder meeting? Because if it was widely publicized, the client of the PDP would not be here stating this position, that it's requested the document and the document was not made available.
Thank you very much. So virtually in all the local government areas, the PDP fielded candidates. In my local government is 100%. It means they were properly notified. And they came. The chairman of the party came. And all the officials, other officials of other political parties came, including security, including INEC, to be part of that meeting. And all of these things were read. Look at what the law says. Look at what the guidelines say. But they needed the CTC. If they do need, they have to go to the proper authority. EPSEC is not the proper authority. It's not the custodian of that very law. And like I did say, the purpose of official gazette is that it is already in the public domain.
Commissioner, you still have not told us, you've not told us the right body to make available that information, because the PDP client is saying that they referred also to the State Assembly and they didn't get it, and then they referred to INEC. But then again, just before we exit this matter, the PDP is accusing Ebonyi state government of perfecting plans to approach Justice Eche Onjoko of the State High Court, who doubles as the vacation judge, to obtain a counter judgment in form or an order to undermine the judgment of Justice Fatun Riman of the Federal High Court, which rendered the recently conducted local government election nullified. So, what are you saying to this allegation of forum shopping to counter the judgment of Justice Fatun?
I may not have been updated about the legal processes. All I know is that the law should follow the procedure. And again, they have the right to ventilate whatever is their grievance, if assuming that there is any such step by the APC in this circumstance. And so let us wait. Let's get to the bridge until we cross. I cannot say what I do not know. But let me assure you that...
just a minute. We're winding down now. So could you tell us, hang on a minute. So when you say that the judgment did not nullify the elections, what is your interpretation of what he ordered?
My interpretation is that they say it's clear that court hereby orders that elections should not hold without first availing the litigants of the laws establishing EPSEC and that makes for the holding of the election.
Okay.
And that INEC should not please give the voters register because it's not a robust stuff.
Okay.
And these actions have been concluded. So it's just an academic exercise which rightly adumbrated.
All right, let's also go to Barrister Enenida as we wind down on this one. So Mr. Oji says the court did not nullify the elections. Is that, do you see it the same way yourself?
Well, because of time, let me quickly run through a couple of things. Number one, you raised it. If the court had said in that judgment that the tenure of the current occupants of those offices, councillors and chairmen, will expire by August next year, what does it say? It simply says that people are still in office. Then let us come to another issue he raised. That is that the judge was on vacation because Uche Noji has been announcing on Ebonyi radio that they are going to go ahead and carry out the swearing in of the purportedly elected new officers, on account that the judge who sat was not supposed to sit because the courts are on vacation. Let me remind him, because he's not in legal practice. He has left practice for a long time. And maybe he also left the law. The action we are talking about, the matter we are talking about, is a pre-election dispute. And there is a circular from the Chief Judge of the Federal High Court mandating and directing all judges of the Federal High Court who are entertaining pre-election disputes to hear such matters even during vacation. That circular is in existence. But before we go, let me say something. Why is the government of Ebonyi State resolving to be lawless by disobeying? And this is not the first time. Judge Seko's judgment, several judgments. Each time judgments don't go in their favor, they will disregard it. Ebonyi State Radio has been announcing that on the 1st of this month, irrespective of this judgment, irrespective of whether it has been set aside or not, they are going to carry out the swearing in. Therefore, saying that we don't obey judgments. Why are they doing so? They are doing this because of the corruption in the local government system. As we speak, 3 months allocation of the local government areas in Ebonyi State are being withheld by officers and agents of the Ebonyi State government. These fellows they want to bring in, these fellows, the courts have said, are not entitled to occupy such offices, are individuals who have one skeleton or the other. They are prepared to sign away their lives. And so, they want to rush them into office,
and take the monies belonging to local governments. And I want to say this. If the Ebonyi State government goes ahead to do that inauguration illegally, we are going to approach the anti-corruption agencies. We are fully armed with all the necessary information. Concerned up as we speak, the June, July, and August allocations have not been released to the local government chairmen. They are making all manner of deductions. For this illegal inauguration they want to do, they have deducted a total of 182 million naira at an average of 14 million per local government. Ebonyi has 13 local government areas. For this inauguration alone, 182 million. Where is it going to? They have deducted 75 million for legal services, for cases they are not doing. So I am sounding this warning. If the Ebonyi State government is lawless and they say they have connected to the center because they are APC and they expect the APC government at the federal level to protect them, time does not run against crime. We are going to approach EFCC, we are going to approach ICPC. And I want to say this about these chairmen who are currently in office. Some slaves like their chains. They can sign away their lives because they have been compelling them to come and sign that their tenures have ended. It is no longer in their mouths to say whether their tenures have ended or not. It is about the judgment, the substitute judgment of the court that has declared that their seats remain the way they are until August next year. If you are not satisfied with the judgment of that court, you approach an appellate court.
And I think it's a fine place to leave it, Mr. Mudera. Erenede, we have to thank you so much for coming on this morning. He's a legal practitioner and representing clients in the local government who were supposed to have participated in the local government elections. But just before we go, I would have to quickly ask this one of Mr. Uche Orji. Is it true that you are ignoring the judgment of the Federal High Court and have been making announcements on Ebonyi State Radio as to when the inauguration of the new ones will be sworn in?
How I wish I had time, I would have just exposed the details of that judgment. The judgment did not say that there should be no swearing in. There's no content like that in the judgment of the 25th day of August 2022. And so we have taken all necessary legal steps.
If the judgment says, sorry to interrupt you, sir, but if the judgment says that it is undemocratic, null and void, hasn't it voided the local government elections? And by extension, meaning that you cannot go ahead to swear anyone in?
To when they challenge the authenticity of our governor being in office, we went on appeal and got that set aside. And today, the governor is still the governor of Ebonyi State. We have never violated the law, and we can never violate the law in this circumstance.
So if I understand you clearly, you're making the announcement. Are you appealing the judgment currently?
Like I did say, I'm not in the legal team, but I can tell you that Ebonyi State government obeys the law, and it has been shown in other previous, decisions of court. And so, whether we are appealing, whether we are setting aside, whether we are coming by any other legal process, what is important is that that judgment is just an academic exercise. The judgment did not say there should be no swearing in. The judgment should not say that the election that has been conducted shouldn't be invalid or should be declared invalid. There was no such declaration or injunction. I stand to be contradicted. I can avail you a copy of that judgment. I have it.
Okay, thank you so much for coming on Sunrise Daily this morning. Mr. Uchenna Orji is the Commissioner for Information in Ebonyi State. Gentlemen, once again, thank you for coming on Sunrise Daily. We'll take a break at this point and we'll be looking at another political matter, this time all the way from Kano State. Please stay with us.